Withdrawal.
Withdrawal, yes.
Well, it is a contempt proceeding. It was on 14/11 it was motion. Just taken, so might say make around 9 million.
Why contempt? What is the urgency?
Regarding settlement of market.
Sorry. Contempt, there is no urgency, no mention memo.
Here.
Yes, madam.
May I please, Your Lordship? I beg to mention item number 8 of today's list, Lordship.
Yes.
My senior Mr. P.K. Roy is not in station. May I pray this matter may be listed any day after Bihu, Lordship?
17 matter, madam.
17.
9 years. 9 years writ petition pending. What do you say to the public? 9 years in the High Court. That to a writ petition. Should not ask for adjournment of a 9-year-old matter. You make things embarrassing for us. Your senior is not there.
Not in station.
Okay, we give, when is he coming back?
Any day after Bihu, Lordship.
Okay, we'll have it on 20th, 20.
Obliged, Lordship. Obliged.
A prayer for adjournment has been made on behalf of the petitioner on the ground, on behalf of Sri P.K. Roy, then Senior Counsel, on the ground that he is out of station. Full stop. Considering that this matter is pending since 2017, as an exceptional case, adjournment is granted with a direction to list this case for hearing on 21.
Obliged, Lordship.
May it please, my lord, pray
Yes.
for listing of a motion matter for tomorrow. Deeply obliged.
Similar prayer. And
Motion.
motion, man.
I have also similar motion.
Similar prayer, man, for tomorrow.
Please, Your Lordship. My lord, I beg to mention item number 10, my lord.
Hmm.
Well, Senior Counsel Mr. K. Chaudhary is appearing in this matter, my lord.
Hmm.
May I pray this be taken up after the Bihu vacation, my lord. Immediately after that.
PNB has been informed.
My lord, the other side is ATP.
Lordship, I'm appearing for respondent.
And PNB?
But the PNB does not have any role in this.
No, you should inform them. We inform them, we'll accommodate, but inform them. Yes, madam.
May please. I beg to mention listing of a new case in motion.
When?
Any date before Bihu.
When, yes.
Pre-block.
Yes, Mr. Gautam.
Lordship, item number 3 and 4, your lordship, this matter is partnered, your lordship.
I'm appearing for the private respondent in this case.
Okay, 2 p.m. That was, we are wondering 2 p.m.
Lordship,
That's,
Huh?
that's.
Yes, sir.
it's partnered.
Well,
Hmm? That's the way. When was the last date of hearing?
No, Lordship will kindly see 17/12/2025.
17.
Oh. Oh. Okay. 2 p.m. otherwise also it will not be possible
No,
today,
no,
perhaps.
approve, let it.
No,
What we'll
today
do it-
perhaps 2 p.m. it will not be possible.
No, what we'll do it, my lord, let it place before appropriate bench. We'll go before registry and according date will be fixed.
Yes, item number 3 and 4.
3 and 4.
My learned friend is there.
Yes,
for
the learned counsel for both the parties have submitted that the matter is partnered by another bench, bracket so and so, registry to verify and list before the appropriate bench.
That's, it's not indicated as a partner, but if you see paragraph 2.
Okay, no,
mostly hard.
I have submitted that the
Mostly hard.
matter has been heard substantially
Substantially.
by
a coordinate bench.
Paragraph 4 states that this matter is fixed on at 2 p.m. for final disposal.
And
Whatever.
there is also an observation for fixing the matter today for final disposal.
Lordship,
I am deeply obsessed.
lordship.
May I please, Your Lordship?
Sorry.
Lordship, I beg to mention item number 6
Hmm.
and 7, Lordship.
Yes, 6 and 7 are connected.
Yes, Lordship.
Yes.
Mr. Decca appears for.
Oendeka is there, okay. Please before any other bench without me.
Liability lawsuit. Liability lawsuit. I beg to mention listing of a new case lawsuit. Motion.
When do you want?
Day after tomorrow. Evening.
No, one matter, my lord. On 30/10/2025, my lord, the court has directed to listed after 6 weeks. This matter was not listed, my lord. Can it be after vacation, my lord?
What is the subject matter?
Contempt matter, my lord, it was.
Sorry. Yes.
Maybe, sir, I beg to mention item number 11.
Yes, 11, yes, what is it?
My senior counsel, sir, he has some personal
Who is
difficulties.
your senior counsel?
A. Das Gupta.
For the petitioner? You are for the
If it is
petitioner.
Possible before the vacation or not after.
Inform the other side.
Yes, I have informed that.
When do you want? 23 matter
If
hearing.
Possible, your lordship, this week. If possible.
This week when? Day after
Uh,
tomorrow?
yeah.
On a request made on behalf of the petitioner, matter is adjourned to be listed for hearing on Thursday. Please give the date.
Objection.
Mr. Kyle? Which one? Okay. Nice.
Only Dasgupta paid for adjournment.
No, let us see. Motion আছে না? There's one motion in the supplementary list.
May it please your lordship. My lord, the present writ petition has been filed challenging the government tender issued by the APDCL, my lord. According to the tender document issued by the APDCL, the MSME firms are not exempted from giving the EMD amount at time of participating in the bid, my lord. And however, my lord, the GEM portal wherein the tender process will be held, in the GEM portal, the GEM terms and condition, the bid document has been issued, according to which the MSME firms are exempted from giving EMD amount, my lord. If your lordship may kindly look upon,
You are an MSME.
yes, my lord.
You are an MSME.
Yes, my lord. I have annexed my Udyam certificate and everything, all the documents have been annexed. Trade
You are aggrieved by the condition that in spite of being an MSME, you are still required to deposit the EMD.
Yes, my lord. Yes.
Yes.
In fact, there are three things which I'd like to point out. Firstly, the GEM portal, it says that the exemption from deposit of MSME, EMDs by MSMEs is only applicable to procurement process initiated by the central government or any of its PSUs. If any procurement process is initiated by state government or its PSUs, then the government at its option may decide to either exempt or not exempt from payment of
The
EMD.
exemption is applicable mandatorily for central government and
Yes.
PSUs,
Yes.
not for state government.
for
It is
state
up to you.
Yes, and in this matter, we have in fact adopted a policy for giving 50% exemption from payment of EMD under the Assam public procurement policy. If they are eligible under that, they may avail of that 50% deduction, your lordship. That is there at page number 27, your lordship.
Sir, Rathi, you participate, will examine your case. We cannot stop them.
My lord, if your lordship may kindly look upon annexure 4, page number 58
Hmm.
of the bid document given in respect to this particular government tender issued by the government e-market, my lord.
Government of
Page number 58, my lord.
58.
It's the bid document issued by the government e-market.
No, GEM is different. Let us see 58. Where
Yes,
is
my
it?
lord. It is
Yes.
pertaining to this particular tender itself.
Yes.
My lord, the date and time, everything, it is only in respect to this tender
Yes.
of the APDCL issued by the.
Yes.
If your lordship may kindly look upon the EPG clause at page number 60.
60.
Yes, my lord. EPBG detail.
Where is
Here,
it?
EMD exemption has been written.
Where is it?
In the top, my
EMD
lord.
exemption is.
The bidder seeking EMD exemption.
GEM is a portal by which the tenders are floated. It's a nodal agency. The decision is not by GEM. Decision is by the owner. Now, you have to show a document by which MSME has to mandatorily be exempted from deposit of EMD for all tenders.
My lord, in respect to government e-market, whenever a tender has been, tender process has been conducted in the government e-market.
First show this document where exemption is prescribed for MSME.
Yes, my lord, that I have only pointed out, my lord.
Where?
Page number 60, my lord.
No, this is one of the tenders.
No, my lord, it is of the same tender.
Yes,
APDCL, the
yes.
tender issued by the APDCL, it is of
Yes.
the same terms and condition issued by the government e-market pertaining to the same tender, my lord.
yes, please read.
The bidder seeking AMD exemption must submit the valid supporting document relevant category as per the GEM GTC with the bid. Under MSC category, only manufacturers of good and the service provider for services are eligible for exemption from EMD. Traders are excluded from the purview of this, my lord.
Hmm.
Subsequently, my lord, if your lordship may kindly look upon.
This pertains to the same tender.
Yes, my lord.
Yes, sir.
It is of the same tender.
Then page
66, my lord. The disclaimer portion.
66.
Yes, my lord. Under the subhead of disclaimer, my lord,
Yes,
if I may read.
please.
The additional terms and condition have been incorporated by the buyer after approval of the competent authority in buyer organization, whereby, so my lord, this terms and condition has been approved by the buyer, that is APDCL, whereby the buyer organization is solely responsible for the impact of these clauses on the bidding process, its outcome and consequences thereof, including any eccentricities, restriction arising in the bidding process due to these ATCs, additional terms and condition, my lord, and due to modifications of technical specification or terms of the condition governing the bid, emphasis applied from here onwards, my lord. If any clause is or are incorporated by the bidder regarding the following, the bid and the resultant contract shall be treated as null and void, and such bids may be cancelled by the GEM at any stage of bidding process without issuing any notice, my lord. If your lordship may look upon point 2, my lord.
Hmm.
If violation is there, seeking EMD submission from bidder, including via additional terms and condition, in contravention to the exemption provided to such seller under GEM GTC, my lord. Point 12, my lord. Incorporating any clause against the MSME policy and preference to Make in India policy. I'll just place the MSME policy, my lord, right now.
Yes, yes, Mr. Pathak.
My learned friend is referring consistently to the GTC and he has not brought the GTC on record. So I brought an extra copy of it so that I can show
Let
you.
us see.
First December. First December. Okay. So if your lordship has the GTC,
Yes,
which was applicable to this tender process,
yes.
lordship will have page number 18.
80, 18, 18.
It starts at 18. I'm referring to clause number M here. Here, Your Lordship. It refers to the procedure for levy and charge of EMD. Clause M, page 18 of 52. So if your lordship turns to the next page, M's subclause 1 on the next page,
Yes,
micro and small enterprises who are holding valid Udyam registration and manufacturer of the offered product or service, primary product stroke service in case of bunch bid with total value wise evaluation, and give specific confirmation to this effect at the time of bid submission, and claim EMD exemption and whose credentials are validated online through Udyam registration website of Ministry of MSME, and also through supporting documents uploaded during bidding process and validated by the bidder. Lordship may take a note of this. State government buyers may, however, choose to exempt only MSCs from the state of bid inviting authority by specifying the same in the ATC of the bid. In case no ATC is included, eligible MSCs of all states are exempted. Then your lordship may turn to the next page. There is a note in bold on page number 19, page number 20.
20.
20. This is what my learned friend was referring to. No EMD to be taken from exempt category of sellers, even by way of specific clauses mentioned in ATC stroke STC. ATC is additional terms and conditions. STC is service terms and conditions. Such clauses which are valid against the GEM GTC will be treated as null and void. Number 2. However, state government stroke state autonomous stroke state local bodies stroke state PSU stroke cooperatives may choose to seek EMD bid from MSC bidders by specifying the same in ATC stroke STC of the bid. In case no such bid is included in ATC stroke STC, EMD exemption as per para M above shall prevail. So if your lordship goes to the document which I was referring to, that is the ATC, that forms a part of the ATC. And there we have made a specific provision for giving some preference to MSCs who are registered under the Assam preference, public procurement preference policy. So at this stage, to seek a blanket exemption for all MSCs, Your Lordship, if he is eligible, let him participate. And
How
ju-
much is the AMG involved?
25 lakhs.
Huh?
25 lakhs.
25 lakhs. And as per your terms and condition for MSME, you have given a 50% rebate.
Yes. And if he's eligible, he can very well. And one more thing, my learned friend was referring to the Assam,
What is the work about?
My lord.
What is the work about?
Providing vehicle, my lord, providing vehicle services.
Vehicle services,
Yes, my lord.
not procurement,
not
Not,
procurement.
it's
Services.
providing services.
service related.
Yes.
Okay.
We'll, in effect, we'll take the vehicles on
On
lease.
hire, on hire.
Yes, yes. Yeah, transportation.
So this MSME procurement policy of the central government, which my learned friend is referring to, even that, Your Lordship, will find at page number 68 of the writ petition.
68,
This is the public procurement policy of the central government.
okay.
So he is saying that under this policy, he should be given an exemption.
Hmm.
But to explain this policy, some FAQs were published, Your Lordship, in the year 2022.
Hmm.
The FAQs are on record and they start at page number 85.
68 is the
Policy.
order,
Yes,
policy.
the policy is at 60 of the central government. And the
Where is the
FAQ,
FAQ's response?
the FAQ response, they start at 85 and the relevant query, Your Lordship, will find at page number 89. It is explaining this policy. Question number 28. At page number 89. Is the public procurement policy applicable to state government stroke state departments stroke state PSUs? Again, the answer is the public procurement policy for MSC's order 2012 is applicable to state government ministries stroke departments and CPSUs. A central government ministry.
We'll examine it. It's for motion, we'll examine.
Very well.
My lord, in this respect, I just have to, my lord, I just have two more contentions, my lord.
Please.
Your lordship may just look upon
Yes,
it.
yes.
My lord, in respect to page number 66, if your lordship is there, my lord.
60?
66, my lord.
Yes,
That disclaimer
yes.
portion which I was reading, my lord.
Yes, yes.
My lord, in the clause 12, which is stating incorporating any clause against the MSME policy and preference to make in India policy. My lord, this bit of,
See, Mr. Rathi, we are at the motion stage.
my lord,
We have to balance the equities.
my lord.
We cannot put a condition which will bring the entire process to a halt. We will ensure that if you are successful in your endeavor, if you, now under the present condition, you are required to deposit 50%. And if you are successful, that 50% will be refunded to you.
My lord, I am seeking totally India exemption.
That will be
My lord,
difficult.
because
Tomorrow, how do you secure that if you are given the contract and you fail in this, your endeavor?
No.
We are in the first blast.
No.
Suppose you fail.
Yes.
Then how do you ensure that equity is done between the parties?
My lord, it's not my terms and condition, it's their terms and
No,
conditions.
we have seen that therefore we'll examine.
Yes, my lord.
We'll
It is
examine.
terms and
We'll
conditions
examine.
issued by the government.
But we cannot put a blanket.
My lord, MSME policy, if your lordship may just look upon the MSME policy.
We have
It-
seen the
it has this
policy.
Big document,
So how do you answer the FAQ 28?
exactly, my lord. If your lordship may look upon question 11, my lord,
Question number 11, page
of the same FAQs, page
Page,
number
page.
87, my lord.
87. Yes.
What are the other benefits, facilities available to the MSME under the policy? To reduce the transaction cost of doing business, MSMEs will
No,
be. facil-
that is a general proposition.
Yes,
Now, there's a specific query regarding the application of organizations which are not central government or which are not PSUs.
my lord.
Discretion is granted to them. That part is not the subject matter of challenge, number one. But we are not going to that at the moment. We'll take your challenge as you have projected. We'll examine.
My lord, if the tender process will commence, then my entire writ petition will become infructuous because I'm just seeking for the.
See, for one person, we cannot stall the process.
My lord, there was a minutes of meeting conducted.
And
My lord,
unless you
just-
make
just-
out a prima facie case, we are still saying that we'll make an observation that in case you participate under the existing clause and you are successful, then the amount has to be refunded to you.
That That is there, my lord. If your lordship may just, my lord, the MSME policy, this is not the question answer. And talking about the MSME policy, which is
May,
stating.
may not be a case for a
It's a
blanket
GEM
stay.
GTC big document is issued by the
Heard,
government.
heard Sri D. Rathi, learned counsel for the petitioners. Full stop. It is the case of the petitioners that the petition number 1, which is a proprietorship firm, is registered as a micro and small enterprise within bracket MSC under the Ministry of MSME, Government of India. Full stop. The grievance of the petitioner is with regard to a tender process in which the benefits of exemption of EMD has not been provided. Full stop. It is the case of the petitioners that being an MSE, comma, there is a total exemption for depositing the EMD in case of a tender of the present nature, which is floated through the GEM. Full stop. Para. 3. KP Pathak, learned standing counsel, APDCL, has however contended that though benefits are provided for MSEs with regard to deposit of EMD, comma, the state, such benefits of total exemption is only for tenders floated by the central government and the PSUs. Full stop. However, a discretion is provided to the state governments and its undertakings to make adequate provision for giving benefit. Full stop. He has also submitted that in the present tender, exemption of 50% has been granted to MSEs. Full stop. The Learned Standing Council has also placed before this court the general terms and condition on the GEM dated 1st of December 2025 and has drawn the attention of this court to clause M,
It's clause 4, Roman 13M.
413M. Full stop. He has also submitted that so far as the state of Assam is concerned, there is the Assam Public Procurement Policy. What is the name?
Assam Procurement Preference Policy,
Assam Procurement Preference Policy
2021.
2021, which is being followed. Para. Let notice be issued, returnable on. When is the date?
Tomorrow.
Tomorrow. You can say returnable on 2nd of February 2026. Union of India, who is there? Union of India. Any CGC? Who was there?
Mr. Gogoi was here. K. Gogoi.
K. Gogoi was there. Mr. K. Gogoi, that is CGC. Except notice for 1. 1 and 3 also perhaps, GEM also.
Yes.
GM, I can CGC can
Yes.
1 and 3. And KP Pathak Standing Council APDCL for response number 2. That extra copy, no? 3. Rathi, the Learned Council prays for an interim order by submitting that the last date for submission of tender is fixed tomorrow. Full stop. He has also submitted that under the policy, comma, there is a total exemption for deposit of EMD by the MSEs. Full stop. He has also,
No policy, apologies, but not policy, bid document.
Under the, he has also submitted that under the bid document, there is a clause for granting total exemption for deposit of EMD by the MSCs. Full stop. Para. The aforesaid submission is, however, disputed by the Learned Standing Council, who has placed reliance in the general terms and condition as mentioned above. I mentioned general terms and condition pertaining to the present tender as mentioned above. Para. Considering the facts and circumstances and by balancing the equities, this court is of the view that passing of a blanket interim order would not be towards the interest of justice. Full stop. However, it is provided that the petitioner would be at liberty to submit its tender under the existing clause of deposit of 50% of the EMD, which, however, would be subject to further orders that may be passed in this proceeding. Full stop. It is made clear that if the petitioner is successful in the writ petition, the EMD deposited would have to be refunded to him in accordance with law.
Much obliged.
Deeply obliged.
You filed your affidavit, would like to examine this
Very good.
case.
Very.
And you have to clarify your bid document, which Mr. Rathi is pointing out, appears to be it's clarified, but you could have used better expression.
That, unfortunately, that format which is used,
Yes, yes.
that is a fixed format
No,
by the
that
GEM.
is the problem in all the matters.
Yes, your lordship.
Some old formats are being used,
Yes.
and in the meantime, there are many developments, improvements which you have not been
In fact,
incorporated.
there PTC does not, tally with the format which is applied.
Previous tender was also cancelled, my lord. The writ
No, you-
petition, it was cancelled.
No, you need to be transparent, and then
Yes.
there needs to be application of
Yes, sir.
mind.
Yes.
Because of these things, litigations are
Yes,
increasing,
sir.
and
I-
you may have a
that-
point tomorrow. Okay, next.
Very good. Deeply obliged.
Much obliged.
Actually, in this case, I'm appearing for the petitioner.
Yes, some mention, some
Probably,
adjournment slip was granted.
yes, Das Gupta has some personal difficulty.
Who has got, you're for the petitioner.
I'm for the petitioner.
Mr. Dasgupta has some difficulty.
Yes, sir.
What is the matter about?
What's the matter relating to the respondent number 2 was not seen the.
Where is the council?
What's it, no, this.
Mention memo, I mean, the adjournment slip is enough. If you are not adjourning,
That's
you
it.
may not
It's not-
accede to the request.
Okay.
This is not the practice. This is only to ensure that if there may be a chance of adjournment,
Yes,
does not ensure that the matter will be adjourned.
Sure.
What is the matter?
Better lordship, the respondent number 2 was working as a nurse in Sankartan Netralaya. There was a dispute, so we should memo to her. Lordship,
You issued
memo to her.
memo regarding dismissal.
Regarding dismissal from
Okay.
service. Ultimately, the domestic inquiry held against her. Then she approached tribunal.
There was some misconduct.
Yes, lordship. There are 11 charges against her. Then lordship.
There was a domestic inquiry.
Yes, domestic inquiry that was challenged before the labor court. Labor court.
Domestic
initially
inquiry culminating into the order of dismissal.
Dismissal.
That was the subject matter of challenge in the labor code.
By labor court.
Thereafter?
Initially, preliminary question was framed by the labor court.
Through a reference
Yes, lordship, there is a reference.
by under 10.
Yeah, undertaken. Lordship, thereafter, that labor court held that the inquiry was proper and but that.
The fairness of the domestic inquiry was the
was-
subject matter of question.
Held to be perfect, lordship.
Okay, then
But she was reinstated and because the punishment was, according to tribunal, it was disproportionate to the.
11A.
Yes, Lord. Thereafter, we approached court, this honorable court, after hearing the satisfied the award and remanded the matter to the labor court again. This time also the tribunal has held that the inquiry was proper, but she was reinstated in service with 60% vacancies with cost of 20,000. Again, we challenge this one before this honorable court. This honorable court initially state the entire proceeding. Thereafter, the workman come with section 17B application.
17B.
But we file application that she is gainfully employed in other organization and she is drawing 1 lakh per month. Thereafter, the matter was fixed to final year. That was denied to her. What's it, now they have abandoned their prayer for reinstatement.
For the benefit under 17B, was any affidavit filed by her? No, by her of not being gainfully employed.
But we filed the application stating that she is gainfully employed earlier also and presently. she
And
was-
your affidavit has been responded by her or not?
Yet not responded.
Not responded.
And Lordship, this honorable court,
What was the nature of services?
she is working as a principal in Nalwadi.
Principal?
Yes, sir. Yes,
In Nalbari what? College or
yes,
school?
it is a, so this is a document.
But that is besides the point. We are in the final hearing or what? Is it for final hearing?
Yes, sir. Now Lordship, they have abandoned their prayer for reinstatement.
Okay.
They are asking for back wages. Only. But our contention is that since she is working gainfully in one of the nursing college, she is not.
Back
entitled
wages for what period?
For from the date when she was dismissed from service. As per there, it is about 50 to 60 lakh. But we file an additional affidavit where we have stated that before that she was working, after dismissal, she was working in Roxy. Now she is working as principal in GNM Training School, Nalwadi Maternity Hospital, situated at Alternative Road, Nalwadi, and drawing salary approximately 1
Okay,
lakh.
well, let us see. I have this when?
What's it on 22nd?
22nd. Twenty-third क्यों बंद हो रहा है? Why is 23rd a holiday?
This Thursday also hearing.
No, positive then. 22nd is okay?
No, sir.
Okay. While the petitioner is represented by Sri S.C. Kyle, a prayer for adjournment has been made on behalf of the respondent number 2 workmen by filing an adjournment slip. Full stop para. Considering the above, matter is adjourned to be listed on 22-1.
Much.
Wait, please also.
Hmm.
So this is regarding non-renewal of stone crusher permit.
Okay, Forest.
In fact, my renewal was rejected on the ground.
Where is Forest Department?
No, I am for the state.
Forest has a rule? Forest is-
Basically, Lordship, we have denying that NOC. We are not providing them the DAG and Patta number because the concerned, the unit where it is situated, the village comes under a non-cadastral village. So,
In fact,
So
I
that-
have filed a
Does
second.
Forest has any rule?
Yes, after getting the NOC from the district authority, thereafter Forest will do the necessary.
But the first hurdle is from you.
Yes, my lord.
Yes,
In
yes.
fact, I have filed another application seeking NOC, my lord. In that application, this order was passed, my lord, directing to provide the NOC. But till then, my lord, they have not provided.
Then what is the fate of this? Is there anything surviving in this petition?
My lord, I have to wait for some time, my lord, because this order was passed on 25th of November.
No, and this present writ petition is 25 writ petition is for what? The present one, 1634?
This is regarding, my lord, non-renewal of my stone crusher permit. For non-renewal, I have to submit a lease deed. Now the condition.
Now you say that
Yes.
in 4548,
Yes,
that is, there is a direction for grant of NOC.
NOC,
Now, after the NOC, I think we adjourn this matter for a
Yes,
while.
my lord.
Okay.
after we vacation.
Okay, okay. Sri N.J. Khatunier, learned counsel for the petitioners, has submitted that in a subsequent writ petition filed by the petitioners, namely WPC, 4548 of 2025, comma, there is a direction dated 25/11/2025 for grant of NOC, which is yet to be done. Full stop. So he accordingly submits that the consideration of this matter be deferred by a month so that he can apprise this court regarding the developments in this case. Para 3 S.R. Borough State Council as well as 3 I. Bothakur Standing Council Forest Department are present.
The first week of
We
February.
give a list
First-
on,
First week of February, madam.
we have it on 5th of February, is it okay?
Yes, madam. Obliged, lordship.
Obliged.
Your Lordship, I tried to contact as per the. I tried to contact them, Your Lordship. I could contact only one of them, Your Lordship, not the others.
Okay.
Your Lordship may passes any orders, Your Lordship, in this. That is.
Okay.
But one thing,
Both are, why two writ petitions?
may I just point it out? The first writ petition was filed saying that please issue us with the accept our documents because these people are not accepting our documents.
Hmm.
We went to them. That's how specific ever meant. So these people are not accepting our documents. So the first case was that please accept our documents and renew our license and allow us to continue without any disturbance. These are the three grounds on which we filed the first case. And there was a stay in our favor, wherein a direction was passed by this honorable court saying that no prejudicial action should be taken without first complying with the due process of law. Now, during the pendency of these cases, they have cancelled our license. So thereafter, the second case came into picture, Your Lordship, that is 5330 of 2023. And during the pendency of that case, they came up with a writ petition saying that we have terminated your licenses.
Not writ petition. They'll not file writ petition.
Sorry, they came up with an affidavit saying that we have terminated your licenses. That's the plea. And that was put to challenge. Your Lordship.
We could, considering,
In fact, Your Lordship, if I may just draw your,
it was okay, wait.
that has to be ratified by the State Council. Why I'm saying so, Your Lordship?
No, now that you'll show cause, you'll take these points.
No,
And
there one thing may I point out.
Yes, Your
As
Lordship.
per my information that what I got my yesterday. In fact, it was by postal address, my lord, by post, it was my lord, furnished to the petitioner, that is our content center. In fact, we have sought for a report from the postmaster. That is.
It is okay, we'll record your dispute that he has not received,
Lord.
but still we'll give some time and you consider and pass the orders.
Only thing may I, my lord, submit that, my lord, this process of, my lord, in this entire process, now, my lord, his name has been removed from the register, and it has been, my lord, published in the official gazette. It will take some time, my lord, if in between, my lord, it is interfered with. Can it be, my lord, this, that, my lord, we will give an opportunity pursuant to the court's order. And so far as the, my lord, the cancellation is concerned, let it be kept in abeyance. If he satisfies, my lord, we will, my lord, automatically. After, my lord, again, long process, we have to move the government.
That will do.
Yes, for
that-
3%.
Your Lordship, that cancellation.
That will do.
That will be kept in abeyance, subject to satisfaction by the petitioner.
If I may,
The order of cancellation would be subject to the final decision which you take after taking into consideration their replies, response.
My lord, I am satisfied.
And you have to take into consideration whatever documents
He will submit.
they will submit along with their reply.
Lordship.
if Your Lordship's kindly permit.
But what
me-
was the main allegation?
Allegation is, my lord, they
Which
are, they
document?
don't have the necessary document to even have the registration. My lord, in fact, thousands of, my lord, pharmacies has been cancelled.
No, let
Yeah,
them
that's why, my lord,
they'll
they
give the
should get the
documents.
opportunity if they are genuine.
If
they
that
should
is
get-
the only reason, the documents are not there, let them give the documents.
Yes, my lord.
Your Lordship will kindly look at page 185. I just want to point it out.
What is it?
That's the cancellation notice in the second case, Your Lordship. Your Lordship kindly takes up 5330. 85. This is one of the cancellation license notices. Second case. The second petition, Your Lordship.
Yes.
This is cancellation notice under section 36(11) of the Pharmacy Act 1948. Sir, with reference to the above, I am to inform you that registration number such and such has been cancelled permanently under section 36(11) of the Pharmacy Act 1948 and removed your name from the register of Assam Pharmacy Council as you have failed to submit any relevant document justifying your qualification to substantiate your eligibility to register as pharmacist in terms of section such and such of the Pharmacy Act in terms of the order passed by the Honorable High Court 3822 such and such. Now, this has a reference of the Executive Committee Resolution number 6 dated 17/8/2022 and confirmation by the State Council under section 36(3) of the Pharmacy Act 21/2023. This falls flat, your lordship, because if your lordship kindly takes up the Pharmacy Act for a moment, your lordship.
See, if they want to verify your documents, let them verify the
I
documents.
have no
Why,
objection.
why are you,
I have no objection.
you're opening all the cards?
No,
If you think that you'll be aggrieved even after verification of document, you can have,
no,
you
I
can
have
still
no
have the point.
objection. I have no objection to the verification. I am readily willing to do so. But if your lordship kindly looks now, what my learned friend has referred to now just submitted, that they want to kept in abeyance. In fact, this notice on the face of it, it cannot stand. That's what I'm saying. Therefore, it cannot be kept in abeyance.
So
It has
without
to go-
verification of documents, you can be, your pharmacy license can be renewed.
Yes, or if they have a case, your lordship.
No, if without verification of documents.
No, I'm not saying without
We
verification.
are only on the, why are you making things complicated, Mr. Sinha?
Your
We are not
lordship,
even dealing with that point.
I'm dealing with the cancellation of the notices. That's what I'm saying, your lordship.
Cancellation of the notices,
Sorry,
licenses,
cancellation of the licenses.
only on the ground of verification of documents.
Your lordship, the issue is like this. First, they have to serve me a notice, then hearing, and then they have to cancel my
That is what
license.
we are trying to do. If you don't want to do that, we'll hear on merits. Please argue on merits. Yes, please argue on merits.
Then your lordship will pass. What I'm trying to say is
No, no,
that.
please argue on merits. If you are obstinate with your submission, we can also be obstinate with our,
No,
we
your
have to
lordship.
answer your queries. We'll answer it
No, your
in
lordship.
accordance with law. And don't think that we'll be prejudiced in answering. We'll answer in accordance with law, strictly in accordance.
No.
Please, as far as I can do. And we'll take into consideration that it was sent to you by registered post PTL.
Yes, in fact, my lord, similar cases, my lord, all has been, my lord, disposed of, granting liberty to the such petitioners to approach the authorities as per the statutory, my lord, provision for appeal. I can, my lord, place, my lord, several, my lord, judgment in this regard. Same bench of, my lord, cancel.
Why should we advise the petitioners to
Yes,
file an
I
appeal?
will
If they
place-
want to file an appeal,
Your
they'll
lordship
appeal.
will pass in that pain.
No, please, Mr. Sinha.
No, I
If
just,
you do not want, if you do not know how to argue after so many years of practice, we cannot help.
your lordship,
Please argue.
what I was trying to say is that.
You have understood, please. You want to show some intricate questions of law, answer something else, please show. We'll appreciate. We'll
No.
consider and appreciate.
I leave it to your.
No,
lordship.
please.
If your lordships kindly
Which
see
provision?
36(1),
Page,
the Pharmacist Act,
section,
section 36.
36.
Removal from register.
Yes.
Subject to the provision of this section, the executive committee may, under the name of the registered pharmacist, shall be removed from the register when it is satisfied after giving a reasonable opportunity of being heard, and after such inquiry, if any, as it may think fit to make, that his name has been entered into the register by error or on account of misrepresentation or suppression of material fact. Now, I have been removed, 36(1), your lordship.
Yes.
Now, if your lordships look 36(2) down
Yes.
below.
Hmm.
An order under 36(1) may direct that the person whose name is ordered to be removed from the register shall be ineligible for registration in the state under this act, either permanently or for such period as may be specified. Number 3, an order under subsection 1 shall be subject to confirmation by the state council. It says subject to confirmation by the state council and shall not take effect until the expiry of 3 months from the date of such confirmation. Now, if your lordships kindly look at the cancellation notices once again.
Yes.
The second para.
Hmm.
This has a reference of the Executive Committee Resolution 6 dated 17/8/2022.
Hmm.
And confirmation by the State Council on 21/2023.
Hmm.
And this notice was issued on 12/6/2023 to me.
Hmm.
So I lose my right to file an appeal, Your Lordship. So on the face of it, this notice go. That was what I was trying to,
Where is the provision for appeal?
the provision for appeal is
4.
4.
Yes.
So if at all, these notices should have been issued to me at best by 17/9/2022, Your Lordship. That's what I was trying to
Will be
say.
subject to confirmation by state council. But 3 does not contemplate about a notice, it's an order.
Yes, Your Lordship.
It's an order.
An order.
This
so
is the
they have
order.
removed me. They've
Yes.
removed me.
Yes.
They've removed me. So an order under subsection 1. Subsection 1 is removal.
Removal.
So once you remove me.
Yes.
So that has to be ratified by the state council.
Yes.
Until 3 months, it cannot take effect.
Yes.
Because my subject to filing of that appeal, that right remains. So if your lordship sees, what I was trying to project is that this is an afterthought of filing of this case. If your lordships kindly see, now they say that this is the reference of the executive committee on 17/8/22 and the confirmation by the state council 21.
Confirmation is of 28th of January 2020. After confirmation, the order of removal has been passed. Or confirmation was on 20th of January 2023. Removal is of 12/6/2023.
Yes, your lordship. So that 3
So
months gone,
what is the fault?
no, that 3 months is gone. I cannot
No,
file
no,
my
no,
appeal.
no, you appeal from which date?
Appeal from after it has been within 1 month, after it has been ratified by the state
From the
council.
date of communication.
Yes, your lordship.
From the date of communication.
No, your lordship, if I may just one thing. An order under subsection 1 shall be subject to confirmation by the state council and shall not take effect until the expiry of 3 months from the date of such confirmation.
Thereafter, after confirmation, it has been confirmed thereafter. A person aggrieved by an order
And the subsequent
subject
one.
which shall
which has
be
been
confirmed by the
confirmed
state may
council
within 30 days from the communication up to him.
up to him.
So it is communicated on 12/6. Where is the prejudice? If you read something else, you can please explain to the court. You may be correct in your understanding.
But what I was trying to. what I
Your
could-
trying has to be backed by law. The provision for filing an appeal is within a particular period from which date? From the date of communication. This has got nothing to do with the date of confirmation. If you do not read properly and you try to make out a case, and this was not which we are intending to, even contemplating to go into. You have failed, you have lost your right to file an appeal. Why should you open the right now?
Well, if he wants to prefer an appeal, my lord, even my lord, after this 3 months also, he can prefer. That I can consider. I can place judgment, my lord. In similar cases, my lord, that opportunity has been given by the honorable court.
The
Directly.
Sinha wants something else. He doesn't want this. What to do, Mr. Sinha? Don't do injustice to your client.
No,
Your client is not even communicating with you. We are
No, no.
trying to do something for them because they had filed the first writ petition. Only for that purpose. That first writ petition was with the cause of action that documents were not accepted.
accept.
If first writ petition was not there, we would not have given so much time to you. Please wait. Both the writ petitions being connected. Same petitioners
Yes, your lordship.
and the petitioners being common and the parties being common, the same are taken up together for an analogous hearing and are disposed of by this common judgment and order. Full stop. Para. The facts in brief are that the petitioners are pharmacists who were registered under the state council, under the state council in accordance with the Pharmacy Act 1948. Full stop. Their grievance was with regard to non-acceptance of the documents for the purpose of renewal of license, which led them to file the first writ petition WPC 8250 of 2022. Full stop. In the said writ petition, there, in the said writ petition, this court had passed an order directing that no prejudicial action be taken without following the due process of law. Full stop. However, during the pendency of the said writ petition, the impugned orders were passed terminating the license, and accordingly, the second writ petition WPC 5330 of 2023 has been filed. Full stop. The primary contention of the petitioners is that such prejudicial action was taken without giving a due opportunity to the petitioners and also in violation of the provisions of the Pharmacy Act 1948. Para. I have heard Sri R. Sinha, learned counsel for the petitioners. Full stop. I have also heard Sri B. Gogoi. You appear as what?
Health Department. Sir.
As the standing counsel, Health Department representing the respondents. Para. Sri Sinha, the learned counsel, has submitted that in view of the contentions of the petitioners raised in the first writ petition, that documents which were submitted by them towards renewal of the license were not received by the respondents, the order of termination would not have been issued. Full stop. He has also emphasized on the fact that there was a specific direction of this court in the first writ petition regarding not taking of any prejudicial action without following the due process of law. Full stop. He has emphasized on the fact that the impugned orders of termination of license has been done without giving any opportunity or notice. Full stop. He has also submitted that there is violation of the provisions of the Pharmacy Act 1948, more particularly Section 36 thereof. Full stop. Para. Per contra, Sri Gogoi, the learned standing counsel, has submitted that the impugned action does not suffer from any illegalities or irregularities, inasmuch as the same were issued by following the due process of law. He has submitted that it was noticed that licenses were issued without proper verification of documents, which led to the present action. He has also emphasized that notices were duly issued to the petitioners, and in this regard, he has placed before this court the communication issued by the concerned postmaster regarding delivery of the registered letters. Full stop. He has also submitted that under Section 36 of the Act, there is a provision for preferring appeal, which has to be done within a stipulated period of time. Full stop. The learned standing counsel has, however, considered that even if the time prescribed is over, comma, the respondent is still willing, would still consider any appeal which may be filed by the petitioners along with necessary testimonials and documents which should be considered in accordance, considered on merits. Para. The aspect of non-receipt of notice, non-issuance oblique non-receipt of notice by the petitioners is disputed by the respondents, and therefore this court, not being a court of on facts, cannot determine the said question. Full stop. However, taking into consideration that the petitioners had earlier approached this court by the first writ petition with the grievance that documents tried to be submitted by them were not accepted, comma, this court is of the view that interest of justice would be done, would be served if the cases of the petitioners are directed to be considered by the respondents in accordance with law. Full stop. Para. In view of the said view is taken by this court by considering that the petitioners claim that they have the valid documents for renewal of their license, which is their specific contention in WPC 8250 of 2022. Full stop. Para. In view of the aforesaid discussion, comma, this court directs, this court gives the liberty to the petitioners to prefer an appeal as provided under section 30 within bracket. Which one? 36 within bracket what? 4. 36(4) of the act in question within a period of on or before, we said that, on or before. Today is 6th. 1, 2. On or before 23rd of January 2026, in which case, along with all the necessary documents and testimonials for both for revocation of the order of cancellation as well as for consideration of renewal of their license. Full stop. If the same is done within the time specified, within the period specified, comma, the same is to be considered by the respondent authorities in accordance with law and without insisting on the aspect of limitation as provided under section 36(4) of the act in question. Full stop. The order of cancellation, which is the subject matter of challenge in the second writ petition, would depend on the final decisions which will be taken by the respondent authorities after consideration of the replies along with the documents. Full stop. The decision taken is required to be communicated to the petitioners in writing, and in the process of such adjudication, comma, the petitioners be given a personal hearing.
May I submit, my lord? Similar cases, my lord, where appeal has been preferred. What I, for that, my lord, Lordship will direct the registrar to consider it, my lord.
Yes, sir.
No, Lordship will direct that for appeal. It will be the government in the health department, not the registrar. All the orders, my lord, passed in similar cases, in similar issues. my
Appeal
lord.
lies before the government.
Government. So in that case, my lord, there is no stay, my lord, of the impugn order.
We are not seeing.
Yes, subject to outcome.
We are not seeing.
Yes.
Okay. And the day they submit their replies, you notify the date on which
Yes.
they will be required to be present in person.
Hearing opportunity perhaps is not there in the statute. Again, it
No,
will
no,
open
no,
up-
no, it's a matter of cancellation, give an
No.
opportunity.
No. Be clear.
Public.
Section 36 से होगा, ये what 30 question लिखे थे. 6.
Made please, Your Lordship.
Yes.
Not the, this matter otherwise is ready for hearing.
Orders wise it for orders.
Earlier it was listed for admission only. Okay, Your Lordship,
It is come for orders.
it has come up for orders.
All respondents served.
Respondent, yes, they are served and the BPCL has,
No, additional affidavit has been filed by the petitioner and please, you have filed additional
I
affidavit.
have filed.
Yes. Yes, is it ready for hearing, Mr. Bhattakur?
Yes.
Can we hear it today?
Yes. Can it be, well, after the revocation? My lord? I am not clear.
What is the issue involved?
But the issue here is, my lord, the petitioner applied for a retail outlet under the BPCA. She was provisionally selected. Subsequently, her selection was rejected on the ground that the lease is not a valid lease because there are multiple owners. Whereas, my lord, the clause says
Lease of the land in
lease
question.
of the land,
Okay.
lease of the land.
You had taken the land on lease.
I have taken the
That
land
is
on
one of the
lease.
permissible aspect, but
Yes.
the lease, the owner, there are
Their
multiple owners.
contentions are there are multiple owners.
And your
whereas
lease
there
is-
were two pattadars.
And the
not
lease was
owners.
not with all the owners.
Yes.
Okay.
My
Now,
lord,
what is your response?
my lord, there are the lesser of the petitioner, my lord, he has purchased a plot of land solely, my lord. There is no multiple owners. There are in that patta, there are other pattadars also. So there is a distinction between the multiple owners and the pattadar. Now they have construed the pattadars as to be an owner, where there is a specific boundary he has purchased from that patta.
No, but if there cannot be a question, but there can be different owners in one dag. But if there is one patta, there cannot be more than one owners in one patta.
No, it can be, my lord.
How
Because
can-
even if it in a patta, if there are other pattadars also, if the acquisition of the ownership is by the other pattadars are not together. Because
No,
here-
it's for a dag. Your contention would be valid for a dag. Under one dag, there can be different pattas. But under one patta, there cannot be different owners. All the owners have to be incorporated in one patta.
no, yes, but the pattadars, my lord, here the pattadars, those who are there, the lesser has purchased a specific boundary, through a sale deed, and
Then
now
he'll have a
now
different
even
patta.
now even
He'll have a different patta.
yes, now the patta has also been separated.
Patta has been separated.
Patta is separated. Afterwards, the patta, and that we have brought on record by one additional affidavit. The apprehension which they
No,
have,
Mr. Bhattakur, as a practical aspect.
Yes.
See, under one dag, there can be the various pattas, but all the names appearing in one patta are deemed to be the owners of the land. Now he says that the patta was not segregated. Now after his purchase, there is a separate patta. So are you disputing that he is the sole owner of the land in question? Or the lesser?
The lesser is not the absolute owner, my lord. But
Or you're disputing that
Yes,
aspect?
because there is no partition
no, the partition is already been done.
after the last date of application.
At that, the lease deed, my lord, was,
See, your eligibility has to be there on the last date. That is
that's
the
true, that's true.
settled position of
My
the
lord,
law. But has any right accrued to him after the last date? It is not like that. Right had accrued to him before the last date.
But as per the clause, my lord.
Suppose, let us take an example that one needs to be qualified by having a particular degree.
Yes.
And the last date, he did not have the degree because results were not out. So he submitted. After the last date, he got the degree. Then you can say that no, on the date of the filing of application, last date, he was not having the degree. You may have a good case.
Yes.
But can it be a very straitjacket formula that in all cases, here, the right has not accrued to him after the last date. Right had accrued to him much before that. It is only a procedural aspect of segregating the patta.
Yes.
Whether you can be slightly, because unless you have any other issues. This was done by draw of lots.
Yes, ma'am. Case of done by draw.
Where is the location?
It's my. Srirang, Srirang.
BTC.
BTC. This salad also is so interesting. There is no registration of the salad matter. By way of additional affidavit, he brought the salad matter. It was unregistered matter.
Oh,
The lease deed, my lord, it's a registered lease deed. By
no,
way
no,
of-
no, no, no. Lease deed can be registered, but we are,
The original salad matter.
if your lesser is not the absolute owner,
Yes. Well,
through a
there's
valid-
no dispute on. By
no, say no, they can do due diligence.
Well,
They have to be satisfied that the land over which a petrol pump would be constructed,
yes, ma'am.
tomorrow there should not be any dispute. That is the sole purpose.
That's the sole purpose.
Either you see, and it has been diluted to a large extent. Earlier,
It is
the
reserved
requirement
for-
was to be an owner. Now they have gone to the extent that you can be a lesser also. I mean, a lessee also.
Let's say.
Hmm.
I say
fact,
corporation
the-
own site, my lord. In
Hmm?
fact, the clause, the site is reserved for corporation own site, my lord. It has to be developed by the corporation, my lord.
Okay.
Whole infrastructure has to be developed by the corporation, my lord.
Which is your HPC,
BPCL, my lord.
BPCL, you will develop the site.
Yes, madam. He has to only consider the boundary along. Here, my lord, if your lordship will kindly see the clause, it says multiple owners. My lord, even if you go by section 44 of the TP Act, my lord, even a co-owner has a right to share even
No,
if
we
it is not
will
partition.
not go into
Of
those.
course, my lord,
Mr.
Yes.
Would have gone if the dispute was between you and the co-owners.
Yes.
I mean, it's not a civil
and there is no
dispute.
dispute with regard to that.
We have to be prima facie satisfied with the fulfillment of the conditions of the tender. But if the sale deed is not even registered,
Yes, ma'am. That to a BTC, my lord.
not registered, there is no valid partition deed.
Yes.
Where is your additional affidavit?
Yes.
What documents have you enclosed?
Page 82, my lord. This is a
Page-
salary matter.
82,
Yes, ma'am. First, my lord, will say page 72.
70,
72.
72. This is Jamabandi.
No, my lord, in page 72 in the right hand side, my lord, will kindly see the partition. My lord. A separate patta has been issued in favor of the.
No, this is the Jamabandi, Jamabandi.
My lord, in the Montebo column, my lord.
No. Where is Jamabandi? This is not the
My lord,
patta.
the order of the circle officer,
No. Where is the patta?
lordship will kindly say page 72. Chakra Bikhoyars, Pullo,
This
Sari,
is not the
2024.
patta. This is only opinion on the Jamabandi. Let's see the patta.
Sir, nowadays the patta is not issued, my lord. Fresh patta is not issued. It is not, yes. The earlier patta used to be issued, my lord. And my lord,
And your sale deed at page 88. It's not a sale deed.
82, my lord. Page 82.
This is 88 corrected. Not a sale deed. It cannot constitute to be a sale deed.
Yes, ma'am. That's only.
Your lesser is Raju Sharma.
Yes.
Sale deed of which date? Which date? Date?
It is of 6/1/2015.
15. You could not have, Raju Sharma could not have purchased in BTC.
Hello?
Raju Sharma could not have purchased land in BTC.
But in the additional affidavit, my lord, I put a.
Can you purchase land in BTC, Mr. Khatanier?
my lord,
After 2003, you cannot.
Regulation, chapter 10.
Not chapter 10.
182.
That is not tribal land, it's BTC is sixth schedule.
City.
Sixth schedule. There's nothing to do with chapter 10 of the tribal belt and blocks. It is even more stricter constitutional provision.
But as per my instruction in the benefit melody.
What is the position now?
There is stay order.
Hmm?
There is stay order.
So stay will be vacated.
But the subject to page 72, which I was trying to point out.
Hmm.
Madam,
No,
that will
you have made your position very clear. We are not saying, using the expression, you have made your position worse. You have made the position very clear. You need to be fair to the court. You have given the sale deed. Sale deed is not a valid sale deed. It could not have been. 2015, a non-tribal could not have purchased land otherwise also. Had it been existing land, ancestral land, partition is there, matter would have been different. Let us not waste further time. Yes, please wait. Please have a seat. The approach to this writ court has been made with the following relief. Please, prayer portion portfolio. As per the facts projected, the respondent number 2 had issued an advertisement on 28/6/2024 inviting applications for awarding retail outlet dealership at various places, including the present location at serial number. Is there any serial number?
Yes.
Serial number ... Namely, within 2 kilometers from
Page 29.
Amguri
Page 29.
20,
29.
29.
Scale number 2, man, name of location within 2 kilometers from the Anguli
20
police station towards
Serial
Bongaigaon.
number 2, name the location to leave, huh? Within
2 kilometers from.
serial number 2, no,
station.
serial 2, no, various locations, including the location within 2 kilometers from page, page 29, not as a wrong Maya. Within 2 kilometers from so and so, huh? The advertisement contained a condition that the candidates would have to be either the owner of the land in question or a leaseholder for 25 years by a registered lease. Full stop. It is the case of the petitioner that a lease deed was duly executed and registered on 15/10/2023 over a plot of land, and accordingly, the application was made. Full stop. After such application, the bid of the petitioner was selected by way of draw of lots. And the petitioner was required to deposit an amount of rupees 20,000 towards initial security deposit, and also to upload certain documents self-attested, which the petitioner claims to have done. Full stop. Further documents were also claimed to have been submitted / uploaded by the petitioner. Full stop. The grievance of the petitioner is, however, with a communication dated 8/6/2024, whereby his application has been rejected. Full stop. The grounds mentioned in the said communication is non-execution of the lease deed by the other co-owner. Full stop. The petitioner also claims to have preferred an internal appeal as provided, which was not disposed of. And on the other hand, comma, the respondent number 3 was selected in place of the petitioner. Full stop. Para. I have heard Sri N.J. Khatoni at Learned Council, sorry. B. Kaushik, Learned Counsel for the petitioner. Khatoni was there in the earlier case.
We look similar.
You should remove your beard. Either you or him.
Usually people get confused with it. Even Mr. Borwa.
I have heard Sri B. Kaushik, Learned Counsel for the petitioner. I have also heard Sri S. Bhattakur, Learned Counsel for the respondent numbers 1 and 2. None appears for the respondent number 3. Para. At the outset, comma, 3. Kaushik, the Learned Counsel has submitted that while moving the writ petition on 27/6/2024, comma, an interim order was passed for maintenance of status quo, which has been continued from time to time. Put stop. Para. He has submitted, the Learned Counsel for the petitioner has submitted that there is no application of mind before issuance of the impugned communication dated 8/6/2024, as the reason prescribed is erroneous and not supported by any documents. Full stop. He has reiterated that the lesser of the petitioner is the sole and exclusive owner of a plot of land measuring 4 bigha, covered by DAG number 229 of PT Patta number 32 of village Lakhipur. LAKI, Lakhipur.
Yes. Lokhipur.
I think Lakhipur, I think.
Lokhipur.
LAKH, I think.
Lokhipur.
Lakhipur under Bizni Murra. And the other documents, including the Jamabandi and Chitha, clearly establishes the said fact. Full stop. He has submitted that there is no dispute to the proposition that the lease deed dated. What is the date of the lease deed?
22/9/2023.
22/9/2023 is duly registered and properly submitted. And in view of such fact, comma, there was no reason to go beyond the requirement under the advertisement in question. Full stop. The Learned Counsel has also drawn the attention of this court to an additional affidavit filed by the petitioner on 17/9/2025, by which he has brought on record the sale deed pertaining to the purchase of the land in question by the lesser of the petitioner. Post of para. The Learned Counsel for the petitioner accordingly submits that the impugned order dated 8/6/2024.
There's one more additional affidavit, 12/12/2024.
Is liable to be interfered with, and a direction is required to be issued for going ahead with the process of allotment with the petitioner. Para. Per contra, Sri Botakur, the learned counsel for the official respondents, has submitted that the reasons assigned for issuance of the impugned letter are germane and relevant, as it is one of the essential conditions of the tender process that the land in question has to be free from all encumbrances, full stop. He has submitted that the applicant can either be the owner of the land in the location or can be a lessee through a valid registered registered lease deed, full stop. He has, however, pointed out that on verification, it transpires that there were multiple owners of the land in question and the lease was executed with only one of the owners, full stop. He has submitted that the aspect that the lessor of the petitioner had purchased the land separately is also belied by the documents enclosed in the additional affidavit by the petitioner himself, inasmuch as the said sale deed is not a registered one. Full stop, para. The rival submissions have been duly considered and the materials placed before this court have been carefully examined. Full stop. The impugned order of rejection, where is that page? Huh?
59.
15,
59.
59.
8624.
Impugned order of rejection dated 8/2/2024.
86.
8/6/2024 issued to the petitioner has clearly assigned the reason for declaring the candidature of the petitioner to be ineligible. For ready reference, the reasons prescribed is expected herein below, page 59, 832. Para. It is not in dispute that such a reason is a relevant reason, and the only requirement of this court is to see whether the said reason prescribed is factually correct or not, full stop. Though this court is not a court on facts, on a prima facie view, the documents enclosed by the petitioner to support his case do not lead this court to come to a conclusion that the land in question is solely owned by the lessor of the petitioner, full stop. The petitioner has relied upon a Jamabandi and also take support of the sale deed in question, full stop. A bare perusal of the extract of the sale deed would, however, show that the sale deed, which was executed sometime in the year 2015, is an unregistered document, full stop. This court has also taken note of the fact that the land in question land in question is in the BTC, which is a 6th schedule area, and the aspect as to whether the lessor of the petitioner, who appears to be a non-tribal, could have purchased land in the year 2015 is itself a doubtful aspect, which this court would not like to go any further. This court is of the view that the application of that there has been application of mind on the part of the respondent corporation, and no mala fide appears to be there in the impugned decision-making process, full stop. In view of the above, comma, this court is of the view that no case for interference is made out, and accordingly, the writ petition stands dismissed. The interim order passed earlier stands vacated.
Obliged.
Item 9. Brahmaputra Technologies. As the forecaster yesterday was mentioning this matter or what? No. None appears for the petitioner on call. Even on the last occasion, that is 2/12/2025. No, none appears for the petitioner on call, whereas Ms. Udas, Learned State Council is present. Even on the last occasion, that is 2/12/2025, there was no representation on behalf of the petitioner, full stop. This writ petition is of the year 2017. And it appears that the petitioner is no longer interested in prosecuting the same, full stop. The writ petition accordingly stands dismissed for want of prosecution. Just a minute. No. Yes, please. Item number 10.
Yes, madam. I made a mention of this matter in the morning, but I could not trace the.
Yes,
concept
yes, yes,
again.
yes. You have some difficulty today.
Mr. Kencho Jason,
Okay. He made a mention. PNB, is anybody appearing for PNB?
Mr. Ganguly was appearing, but nobody has filed affidavit yet.
Okay, okay. On the prayer of 3. Anne Barua, Learned Counsel for the petitioner. Matter is adjourned. To be listed on
The 19th.
reopening, 19th. Can we, this is for a hearing, isn't it?
Well, this is for
19th.
hearing.
So not 19/28/20?
Well, Then can it be on the 20?
The 19th, let it be on 19th,
Right.
19th, maybe possible, 19th.
I for the respondent number 5,
Who's 5?
BPPA for lot.
Okay. Miss Udas, Learned State Council, and Miss MDB, Learned Council for respondent number 5 are present.
Obliged.
So Ghosh,
My lord, in fact, Lordship, this matter has already been heard and only the judgment is required to be passed.
Also submitted written argument.
okay, okay, then let it go for the, which court?
This is
Justice,
court number 18, Lord. My
18.
Lord Justice, you can.
Okay.
That is reserved by his lordship, my lord, you have to file written argument
Okay,
also.
okay, both Sri BJ Ghosh, Learned Counsel for the petitioner, and Sri P Nayak, you are appearing for?
For the state, Lord.
Sri Nayak, Learned State Council, have jointly submitted that this matter was, has been heard,
Substantially hard.
was substantially heard, and as per direction of this court,
That's deserved.
as
Deserved by this.
and written arguments were also also filed by the respective parties, full stop. Substantially heard by a coordinate bench within bracket, Justice UK Nair, registry to verify and list before the appropriate bench for hearing.
Apply, sir.